Okay, so welcome everyone. Good afternoon. Welcome to our IP Osgoode Speak series. We have an exciting event with us today, and from a speaker who hails from Australia. So, and all of you here in the room is a great indicator of the interest in the topic, which, as we were saying earlier, has finally made the mainstream media here in Canada. So, very hot topic, and I'm sure all of you are eager to hear more about and ask lots of questions. I'm Professor Giuseppina D'Agostino, and on behalf of IP Osgoode and also the Research Office, thank you so much for joining us today. Now, I should mention that today's event is being audio recorded, and the recording will be accessible online on the IP Osgoode website, so iposgoode.ca. For those of you who haven't already accessed the website, please do so. It contains all that is new and exciting in IP here in Canada and around the world. And I'm very pleased to say that Aviv Gaon, who's sitting right there, he's our newest addition to the PhD program, actually my very own PhD student, will be blogging on today's event. So Aviv, do a good job, all right? So please do check out his posts and feel free to infuse your own comments and questions there. Also, feel free to tweet away, those of you tweeting in the room, hashtag IPOSpeaks. So get your phones ready. Now, today's event is possible, and here we're very grateful to Professor Karis Craig, who tipped us off of Matthew's whereabouts and said we need to host Matthew. So it's thanks to Professor Craig that you're all here today, and also for hosting today's lunch, and her research office, Jodianne Rowe Butler, sitting right there, taking all the names and really responsible for all the organizational skills, right, along with Michelle Lee. Where's Michelle? There you are, of course. So Michelle Lee, who is really the force behind IP Osgoode. So thank you all very much. Thanks also to the founding IP Osgoode sponsors, Castles, Gowlings, and McCarthy's, for always supporting us. Now, I should mention that those of you aware, IP Osgoode, we're very busy. Our goal is always to infuse many more voices to the IP debate and enhance the learning opportunities for our students here in Canada and around the world. And I think today's event is a great example of us doing that. So we're very pleased that you're here, and I'm going to introduce you to Professor Karis Craig, who actually heads also the research office here. So she also has the hat of Associate Dean, so she's very busy, keeping up the scholarship, the teaching, and doing all the admin, right? So she will be introducing our guest speaker today. So with that, thank you very much, Professor Craig.
Thank you, Peter. Professor D'Agostino, I should say. Okay, so thank you. I'll keep this quick. I want to get on to the main event, but it's hard to keep it quick because Matthew's, Dr. Rimmer, I should say, his CV is so extensive. So I'll just give you a little taste of what he does, and then I'll pass things along. So Dr. Matthew Rimmer, our speaker today, is a professor in intellectual property and innovation law at the Faculty of Law in the Queensland University of Technology. So that's QUT. So he's a member of QUT's Intellectual Property and Innovation Law Research Programme, a member of their Digital Media Research Centre, the Australian Centre for Health Law Research, and their International Law and Global Governance Research Programme. Before that, he was at ANU College of Law and a research fellow for the Australian Centre of IP and Agriculture. He has a BA and a University Medal in Literature and an LLB Honours from the Australian National University and a PhD from the University of New South Wales. For his dissertation on the Pirate Bazaar, the social life of copyright law. So he's published very widely on a slew of topics across the field of intellectual property and innovation and technology. That includes patent law and biotechnology, access to medicines, plain packaging of tobacco products, which is a big issue right now in the trademark field, intellectual property and climate change, Indigenous intellectual property. He has his book, 2007, God, time flies, was Digital Copyright in the Consumer Revolution, Hands Off My iPod, which is still one of my favorites, although it's getting a little dated with the iPod. Okay, intellectual property and biotechnology, biological inventions, climate change, the list goes on. Basically, if you ask him anything about any topic, even tangentially related to anything to do with information, innovation, or IP, He will tell you 3 things about it you didn't know, the names of 3 people who are working on it internationally. So this is like a test I'm putting you up to, but so far you've passed every test. So his talk today is on the Trans-Pacific Partnership, as you know, a very hot topic. And of course, with the signing of the deal just a few days ago, it couldn't be more topical, it couldn't be more political, and I'm sure you're very excited to get on to the main proceedings. So with that, apologies for the length of the introduction, but I missed out more than you know. Here is Matthew Dr. Rimmer. Thank you.
Thank you very much for the warm welcome. It's lovely to be here at Osgoode Hall at York University. Certainly in my own career, I've been heavily influenced by researchers from these fine institutions. Barbara and Coombe, particularly in the 1990s when I was kind of starting out as an intellectual property academic and researcher, had a big influence on my work. And it's great to see what a dynamic, creative group that you have here at Osgoode Hall. It's been kind of really impressive visiting here and having a chat to you about your various intellectual activities around intellectual property. My talk today is on the Trans-Pacific Partnership, copyright law, the creative industries and internet freedom. It's the perfect time to talk about these particular topics because there's been an agreement reached this very week in Atlanta on this massive trade deal cutting across the Pacific Rim, binding Australia, Canada, the United States and many other countries to high standards across a score of different regulatory fields, but particularly a kind of harmonising areas of intellectual property. So it's a really good time and opportunity to be here talking about these particular topics. And also I've been kind of enjoying all the excitement of the Canadian election, in which your political leaders have been busy fighting over the Trans-Pacific Partnership, even though some of them don't necessarily have the benefit of the text of the agreement. And to me as an outsider, it seems extraordinary that the Harper government has been busy negotiating the Trans-Pacific Partnership while it's been in a caretaker government mode. So it's been quite fascinating to see how that kind of debate plays out. So those are my kind of contact details if you need to contact me. I kind of lead a group of about 8 researchers and about a dozen research students at Queensland University of Technology in Brisbane, in Queensland, the Sunshine State. As was kind of mentioned in terms of the kind of introduction, I have various different kind of interests in relation to intellectual property, and my kind of current work in relation to the Trans-Pacific Partnership brings them all together and aggregates them and joins them together. But as Kara said, I've done a lot of work on copyright law in the past, and really today's talk is kind of informed by some of those experiences. So in the 1990s, I was kind of considering some of the impacts of the TRIPS agreement, particularly in respect of copyright law. Then a decade ago with the Australia-United States Free Trade Agreement, Australia had a copyright term extension and implemented TRIPS Plus standards in relation to copyright law. And now, at the end of that kind of 20-year period, we see kind of the push for TRIPS Double Plus standards in the Trans-Pacific Partnership. So in many ways, the talk today has a lot of continuity with that work that I've done before. I just wanted to kind of mention some really revolutionary developments taking place in Australia. I've done a lot of work in relation to gene patents, and just the other day, the High Court of Australia ruled 7-0 against Myriad Genetics in respect of their patent application in respect of BRCA1 related to breast cancer and ovarian cancer. Fascinating 100-page decision with 3 judges kind of offering some remarks. Chief Justice French, who's very interested in intellectual property and science, kind of emphasised that really what Myriad Genetics was trying to claim was genetic information, and that wasn't the proper subject matter of patent law. There's also a very kind of strong theme in the case about the potential dangers of overbroad gene patents impacting upon the freedom to research and the freedom to invent. So, fascinating new precedent out of the High Court of Australia, well worth having a look. It was striking that the Children's Hospital of Eastern Ontario, who are running a challenge against gene patents in Canada, were instantly tweeting about the decision online and saying how useful that precedent would be in their challenge in Canada. So really interesting development out of Australia. I've also done a lot of work on access to essential medicines. But I've also kind of done a lot of public policy work and academic work on plain packaging of tobacco products. So I was kind of part of the group of health researchers who made the case for plain packaging of tobacco products in Australia. Our Attorney General and Health Minister, Nicola Roxon, picked up that idea and ran with it and passed legislation introducing plain packaging of tobacco products in the Australian Parliament. Our High Court of Australia, a few years ago now, ruled 6-1 in favour of the Commonwealth in the constitutionality of plain packaging of tobacco products. So the tobacco companies had challenged the legislation and argued that it was an acquisition of property on something other than just terms. The High Court of Australia kind of handed down a really interesting decision talking about public health, intellectual property, constitutional law, the introduction of labelling schemes. But they were very much of the view that intellectual property was designed to serve higher public purposes. At the moment, the World Trade Organisation has heard a challenge by 5 nations against Australia's plain packaging of tobacco products. It'll be very interesting to see the decision coming out of the WTO on plain packaging and whether or not it's consistent with the TRIPS agreement and the Technical Barriers to Trade agreement and GATT. And there's also been a kind of an investor-state dispute settlement being run against Australia's plain packaging of tobacco products. So we've spent $50 million thus far defending our plain packaging against Philip Morris, who shifted their assets to Hong Kong. So once they lost the High Court case, they could mount this kind of collateral attack upon the decision through this investment agreement. And our Chief Justice has been very concerned about the impact of investor-state dispute settlement upon the judiciary and domestic courts and lawmaking. And it's notable that he's kind of referred to the great battle in Canada over drug patents between Eli Lilly and the Government of Canada. And he's kind of been very concerned about IP owners using investor clauses to mount attacks against decisions of superior courts that they find objectionable. So really interesting developments at the moment in Australia and internationally in relation to plain packaging of tobacco products. I've also done a lot of work on intellectual property and climate change and intellectual property and emerging technologies. I'm just finishing a big edited collection at the moment on Indigenous intellectual property. But today I want to talk about the Trans-Pacific Partnership. The Trans-Pacific Partnership is a blockbuster trade agreement cutting across the Pacific Rim. The agreement kind of covers NAFTA countries like Canada, the United States and Mexico. It includes Latin American countries such as Peru and Chile. Australia and New Zealand are involved. Malaysia, Brunei, Singapore and Vietnam are also members of the agreement. And Japan kind of entered late in the piece in respect of the negotiations in relation to this agreement. Initially, the Trans-Pacific Partnership started off as a very modest affair. So New Zealand was very envious of Australia and wanted to have a trade agreement with the United States like Australia. So it was trying to band together a few countries to make the prospect of a trade agreement somewhat more attractive. George W. Bush initially was kind of quite keen on there being a Trans-Pacific Partnership. And then after a year or so of the Obama administration, Obama really kind of pursued some of the prospects in relation to the Trans-Pacific Partnership. The geography of the Trans-Pacific Partnership is very strange. It's the child of a couple of geographers. It's very notable who is not in the agreement. It's notable that some of the key BRICS basic countries are not in the agreement, like China, Brazil, South Africa, India and Russia are all kind of excluded. Many developing countries and least developed countries throughout Southeast Asia are also outside of the agreement. And the Trans-Pacific Partnership doesn't actually include any kind of Pacific small island states in terms of the scope of the agreement. So it's very much a kind of a fictional geography in many ways, a coalition of the willing that has been really kind of developed by the United States as part of a kind of a larger kind of global trade strategy. The United States has become very frustrated that it hasn't been able to get its way in the World Intellectual Property Organisation or the World Trade Organisation, so it's been pushing for these grand regional agreements. The Trans-Pacific Partnership is one. There's also the Transatlantic Trade and Investment Partnership, which is a proposal to do an agreement between the United States and the European Union. And then there's also the shadowy spectre of the Trade and Services Agreement, TISA, which is meant to cover a score of different countries. The Trans-Pacific Partnership of late has been the subject of a great deal of controversy over the radical secrecy surrounding the agreement. And the very kind of closed interpretive community in which has kind of negotiated the kind of content of the text. My wife, Susan Harris-Rimmer, teaches gender and diplomacy, and she has stolen this particular slide from the Sydney talks. There's been a great deal of concern about the lack of transparency, the lack of accountability, and the lack of public participation in the Trans-Pacific Partnership talks. Essentially, as opposed to, say, the World Intellectual Property Organisation, which is quite open and transparent in terms of the negotiations that happen in relation to matters of intellectual property, the Trans-Pacific Partnership has been shrouded in secrecy. The United States Trade Representative has been heavily influenced by its industry advisory groups. So special industry advisors have had access to the text of the agreement and often dictated what they think should be in the text. And the executives of the dozen countries negotiating the Trans-Pacific Partnership have had access to the text. But legislators across the Pacific Rim have not necessarily been allowed to see the text. A few have been allowed to see the agreements, but under conditions of strict confidentiality. So a few Australian politicians went down to the dungeons of the Department of Foreign Affairs and Trade and were able to see the text, only if they never spoke of what they saw again for the next several years. So that has been a kind of a very disturbing part of the discussion, and it's been very noticeable in the recent talks in Atlanta and those before in Hawaii, how civil society have been locked out of the meetings and the discussions, how the general public has not necessarily had access to the text. And we still don't have access to the text. So it's incredible being in Canada, you're debating the Trans-Pacific Partnership just before the election, and no one has any surety about what is the actual kind of finalised content in terms of the agreement that is there. President Barack Obama is a paradox when it comes to trade agreements. When he was running to be president, President Barack Obama was an ardent critic of trade agreements. He, in presidential debates, complained that the North American Free Trade Agreement was a bad deal, it should be revised, it should be repealed. The agreement was toxic to labour rights, to the environment and public health. Since becoming president, he has been busy pursuing agreements far more ambitious than the North American Free Trade Agreement. And it's been strange to see kind of the investment of energy and time and effort by the president in the Trans-Pacific Partnership, to the extent to which, he's gone off to the United States Congress and personally lobbied members of Congress to try to get a fast-track authority so he can present the deal on a take-it-or-leave-it basis to the United States Congress. He was personally ringing up the leaders of various countries just before the conclusion of the recent talks. So he called the current Australian Prime Minister, Malcolm Turnbull, and lobbied him to accept the demands of the United States in relation to special protection in respect of biologics. To me, there's something very kind of curious that Barack Obama, as part of his legacy, should be so intent upon the Trans-Pacific Partnership. As someone who came and promised that he was going to change politics, it seems a very kind of strange legacy to have negotiated this rather plutocratic Trans-Pacific Partnership with the help of a lot of Republicans in the United States Congress and a few splitters from the Democratic Party. There's something kind of quite curious going on in terms of the impetus for the Trans-Pacific Partnership. We just had the conclusion of the Atlanta talks. There was something very kind of surreal about the Atlanta talks about the Trans-Pacific Partnership, partly because, it's home to Coca-Cola, great trademark owner, and TPP champion and sponsor. So there was a certain kind of strange sense. The talks were running overtime, and the Foo Fighters were also based at the same hotel as all the negotiators. So I have this kind of strange image of Dave Grohl and the negotiators kind of passing their breakfast cereal. But, at the end of the discussions, really there was a kind of an agreement for there to be a finalised deal. And from an Australian perspective, there was a kind of a great deal of interest in terms of the agreement. So our Trade Minister, Andrew Robb, was very intent upon concluding the agreement in relation to the Trans-Pacific Partnership. Just to give you a quick overview of the Trans-Pacific Partnership is sweeping. So it covers some very kind of traditional matters of trade, like market access and tariffs. So questions about access for dairy farmers to other markets and those sorts of questions. But it also deals with a wide range of other forms of regulation, like intellectual property, investment, public health, the environment, labour rights, questions about financial regulation, telecommunications, electronic commerce. The agreement is very ambitious, not only in terms of its membership, but also in terms of its content. And it's very detailed and prescriptive, as we can kind of see from some of the leaked texts that we've seen. So very kind of dramatic scenes in terms of the conclusion of the agreement. It's kind of interesting from an Australian perspective. Australia fought quite hard on certain intellectual property topics, so we seem to have kind of resisted the United States having special, extra extended terms for biologics, and we seem to have some defences in place to protect plain packaging of tobacco products, but on other issues we seem to have kind of capitulated in one way or another. Now, Australia has had somewhat kind of confusing domestic politics of late. We've had 5 Prime Ministers in the last 5 years. Our current Prime Minister, as of the moment, is Malcolm Turnbull. So he rolled Tony Abbott as leader of the kind of Conservative coalition. Malcolm Turnbull has long had a very kind of strong interest in matters of intellectual property. So he made his name in the 1980s as the barrister in the spy catcher case, defending a spy who wanted to write his biography against the British government. In the 1990s, in the dot-com boom, one of his ISPs got sued for authorising copyright infringement. Often, more recently, he's had to kind of implement some of the copyright laws under Tony Abbott, but he's also sometimes been kind of quite critical of certain things. So, for instance, he's quite an ardent critic of gene patents. Malcolm has a certain way with words, and he was promoting the Trans-Pacific Partnership as a foundation stone for our future prosperity in Australia. So he was basically arguing that the agreement would present wonderful opportunities for Australia, and Australia should ratify and agree to the Trans-Pacific Partnership. By contrast, our opposition leader, Bill Shorten, has been somewhat more ambivalent about whether or not he will support the agreement. He's been kind of concerned about the secrecy associated with the deal. He's been concerned about how it might impact upon matters like public health and sovereignty, but he's been kind of unwilling to kind of commit to a position. So last night, Australian activists Get Up were kind of prompting Bill Shorten to kind of take a stand. Last night, Hillary Clinton came out and condemned the Trans-Pacific Partnership as an agreement that was not a progressive 21st century agreement as Barack Obama had claimed it was, and she expressed concerns about how it dealt with jobs and public health and currency manipulation. And there's been a kind of a bit of pressure upon our main opposition party to take a stance. And I guess the main opposition in Australia has come from the Greens, who kind of hold about a dozen positions in the Australian Parliament, who have been very concerned about how the Trans-Pacific Partnership will affect the environment and climate change and public health and labour rights. And there's also been some enterprising cross-branches like Nick Xenophon, who's been very concerned about how the TPP will affect manufacturing industries, and some ALP members on the left side of politics like Melissa Park, who have been quite concerned about the deal. And there's been some quite funny cartoons from Australian cartoonists. This is probably a little bit small for you, but this is called First Dog on the Moon. But he says, trade agreements are super boring, so nobody really cares. And because it's secret, there's nothing to argue with anyway. It's hard to get people angry about how we're not allowed to see this super boring thing. I think it kind of has a nice point that, the Trans-Pacific Partnership is a useful, bland vehicle to pass lots of very controversial and sometimes quite unpalatable measures. So it's been fascinating being in Canada and seeing how the debate has played out here, and there's been lots of kind of parallels with what's been going on in Australia. It's nice to see that there's been a bit of front page coverage of the Trans-Pacific Partnership in terms of the Canadian discussions about the topic, and in some ways very similar divisions to what's been going on in Australia. So Stephen Harper's busy trying to sell the Trans-Pacific Partnership as part of his grand plan to protect our economy. Thomas Mulcair from the NDP has been saying that he's going to oppose the deal because he thinks that it's bad for family farmers and will be no good for auto workers and will raise the price of medicines. And he's saying he won't be bound by any secret deals negotiated by Stephen Harper. And Justin Trudeau from the Liberals has been somewhere in between, much like Bill Shorten, saying he's concerned about the secrecy of the deal, he supports free trade, he will wait to commit himself when he sees the kind of final text. It's noticeable, though, in terms of the discussion of the agreement, what topics get covered and what topics are not properly covered. So there's a lot of emphasis upon cows and cars in the Globe and Mail coverage, and a little bit upon medicines, but not a lot of discussion yet in relation to matters of intellectual property. So today I want to kind of have a look at one sliver of some of the intellectual property issues raised by the Trans-Pacific Partnership and how Canada will particularly be affected by some of the measures proposed. Much of what we know about the copyright parts of the Trans-Pacific Partnership come from leaks by enterprising whistleblowers. So the agreement has been shrouded in such secrecy, we've been most obliged by WikiLeaks and Julian Assange revealing draft chapters of the Trans-Pacific Partnership. So a couple of years ago, I got a very kind of interesting phone call from some Fairfax journalists who said that they got hold of the intellectual property chapter of the Trans-Pacific Partnership and would I mind having a look and giving them a few pointers about what they should focus upon. And essentially, Julian Assange had made a bit of a comeback. So hitherto, he was considered to be a spent force, locked up in the Ecuadorian embassy in London and trapped there and unable to really pursue some of the activities that WikiLeaks had made its name doing. But he's had something of a renaissance, getting hold of key texts of both the Trans-Pacific Partnership and some of the other deals, and quite strategically and astutely leaking them to academics and journalists who have done quite a good job at kind of analysing some of the key components of the deal. So in relation to intellectual property, it really kind of shifted the conversation about what was happening in respect of the Trans-Pacific Partnership. So the Huffington Post kind of noted the Obama administration is seeking radical new powers for corporations. More recently, at the end of the Hawaii talks, we got a much better idea about what was actually in the intellectual property chapter of the Trans-Pacific Partnership when Jamie Love's Knowledge Ecology International published the most recent draft text of the intellectual property chapter. Jamie said in many sections of the text, the TPP would change global norms, restrict access to knowledge, create significant financial risk for persons using and sharing information, and in some cases impose new costs on persons producing new knowledge goods. So the agreement in relation to intellectual property is very sweeping and quite transformative, both at the level of principle in terms of the policies and objectives being served by intellectual property, but also kind of doctrinally. It's quite transformative in terms of many of the kind of fundamental doctrines and rules that exist in relation to copyright law, but also in relation to trademark law and patent law and in relation to kind of trade secrets. So I just want to kind of go through some of the kind of the key headline issues in relation to copyright law and the Trans-Pacific Partnership. So I want to talk a little bit about the debate that's gone on in respect of principles and objectives. I want to talk about how the Trans-Pacific Partnership is a Mickey Mouse deal, how the Trans-Pacific Partnership is designed to promote longer copyright terms, particularly to benefit Disney and Hollywood and the music industry. I'd like to discuss the rather murky debate that's kind of taken place in relation to copyright exceptions. And then I want to kind of talk about how the United States wants to export elements of its anachronistic Digital Millennium Copyright Act from the 1990s, particularly some of its rules in relation to intermediary liability, but also some of its broken old models of Uber copyright, like technological protection measures and electronic rights management information. There's also some very curious things in the agreement hidden away in relation to television broadcasts, but there's also very much a heavy emphasis upon intellectual property enforcement in creating a discipline and punish model in relation to intellectual property law with civil remedies, criminal offences and border measures. So a lot of the proposals that were kind of contained in the Stop Online Piracy Act and the Anti-Counterfeiting Trade Agreement, ACTA, which were considered to be incredibly controversial and rejected, have been absorbed and assimilated into some of the proposals in relation to the Trans-Pacific Partnership. So it's a wonderful example of policy laundering, and in terms of taking things that have been in past rejected agreements and pieces of legislation and moving them into a larger trade agreement in which they can kind of be bundled into a much larger debate. So instead of just dealing with the copyright matters or the intellectual property matters in isolation, a country like the United States has a stronger bargaining position by saying you must comply with these IP standards if you want to get market access to the United States at the levels that we're going to offer. At a very fundamental level, I think the Trans-Pacific Partnership really changes the way in which we think about intellectual property and copyright law. So, traditionally, copyright law was designed in terms of the United States language to promote the progress of science and the useful arts. For countries like Australia and Canada and the United Kingdom, there's a very strong emphasis upon the encouragement of learning and access to knowledge. I think the Trans-Pacific Partnership is kind of quite radical in terms of there's a very heavy emphasis upon intellectual property, promoting the rights of foreign investors, particularly multinationals, who have various different kinds of intellectual property assets. So I think we're kind of in an interesting period in which this agreement is trying to kind of change some of the kind of underlying norms in relation to intellectual property. So in terms of the kind of the draft text that we've seen, there's a bit of discussion about the various competing public policy objectives for national systems, including promoting innovation and creativity, facilitating the diffusion of information, knowledge, technology, culture and the arts, fostering competition in open and efficient markets, and through their intellectual property systems while respecting the principles of transparency and due process and taking into account the interests of relevant stakeholders, including rights holders, service providers, users and the public. And then there's a bit of a debate about whether or not there should be an acknowledgement about the importance of the public domain. Japan and the United States, even though domestically have recognition of the public domain, have been trying to exclude some sort of recognition of the public domain in terms of the principles and objectives being sought to be protected in relation to intellectual property in the Trans-Pacific Partnership. And I guess such statements kind of reveal not so much a philosophical debate, so much as a kind of underlying will to power, a kind of a political struggle going on between different kind of copyright stakeholders. So obviously the US Chamber of Commerce has been very influential in the Trans-Pacific Partnership in promoting what it calls diamond standards in relation to intellectual property. Hollywood, particularly the Motion Picture Association of America, wants longer, stronger copyright protection, as has the music industry, which has kind of been very keen on harmonising and standardising high levels of intellectual property protection. I think much more interesting has been the tacit support of some other organisations. So the Computer and Communications Industry Association, a very influential peak body that represents software developers like Microsoft, but also kind of some of the big players like search engines like Google, seems to be that organisation supported fast track for the Trans-Pacific Partnership, even though it has quite a tough intellectual property regime. So there seems to be some sort of hidden deal that's being done. Perhaps the payoff is the electronic commerce chapter, which Google and Facebook and IBM and others are very kind of keen on. Similarly, the Consumer Electronics Association has given support for the fast track of the Trans-Pacific Partnership. this is shocking because they used to be the great defenders of consumer rights in relation to copyright law. They were the ones who were championing the Sony Betamax decision and how that should be applied in a wide range of different circumstances. And here you have Gary Shapiro, the same person, giving his support for this regime in relation to the Trans-Pacific Partnership. So something very interesting has kind of taken place in terms of some of the corporate arrangements behind the scenes in relation to the Trans-Pacific Partnership. A wide range of different digital rights groups have kind of opposed the proposals in relation to the Trans-Pacific Partnership. So the Electronic Frontier Foundation and the Fight for the Future in the United States. Open Media has been very active here in Canada, as has Michael Geist and a few others. In Australia, there's been quite a few groups and organisations who are very concerned about how the Trans-Pacific Partnership will impact upon privacy and internet freedom and questions about freedom of speech. And I guess it's kind of a very kind of disturbing moment in terms of the evaporation of certain notions of the public domain, both at the level of principle, but also through pushing for things like copyright term extension. So a perennial classic question in relation to copyright law is the question of term and duration. What should be the term of protection provided for authors and publishers and various creative artists? And really there's been a kind of dramatic push over the past couple of decades for there to be a copyright term extension. So when I was doing my PhD in the 1990s, I was interviewing the filmmakers who did the film Shine, which has a lot of the music of Rachmaninoff in it. And they found that as a result of upward harmonisation in the European Union of the copyright term to life plus 70 years, the work of Rachmaninoff came out of the public domain, back into copyright protection, and they had to fend off claims for moral rights infringement and economic rights infringement. Very strategically, Hollywood and the music industry argued that the United States Congress should follow the lead of the European Union and have a copyright term extension. And the Sonny Bono Copyright Term Extension Act in the 1998 was a very radical development in which term was extended in the United States. There was uproar about the push for the copyright term extension. Lawrence Lessig and Eric Eldred ran a constitutional challenge against the Sonny Bono Copyright Term Extension Act in the Supreme Court of the United States. The majority of the Supreme Court of the United States held that it was constitutional, but Breyer and Stevens objected that it was beyond the power of the US Congress and would have adverse impacts upon cultural heritage and competition in the public domain, and it wouldn't create any new incentives having a longer copyright term. Walt Disney wasn't going to create any new works by having 20 years extra protection. And in Australia, we then were kind of compelled to follow suit, and we were asked to have a copyright term extension as part of our TRIPS Plus Australia-United States Free Trade Agreement in 2004. Very heavy pressure from the United States for us to follow suit. We did hold our ground on the question of revival of works from the public domain. So we said if something's in the public domain, it will stay in the public domain. We won't allow for revival of works. There's been some huge battles over long vintage copyright works. So in Australia, our unofficial national anthem is the Down Under song by Men at Work. Are you familiar with the Down Under song? Great hit and a great success. There was a transfer of copyright ownership from an estate of Marion Sinclair, who kind of created a song called the Kookaburra Song for Girl Guides, and a record company called Larrikin Records picked up the copyright for that. And then they sued EMI, and by extension Men at Work, for copyright infringement, saying that the little flute riff in the Men at Work song was an infringement of the Kookaburra classic song. And in that particular case, the judges found that there was a copyright infringement, but a number of the judges had deep reservations about long copyright terms and the impact that that had upon the balances being struck within copyright law. Colin Hay, the lead singer from Men at Work, is outraged by the decision, and he still plays the song. He just leaves out the little riff part with the Kookaburra part. And for some issues, we've had some really kind of peculiar problems with perpetual copyright in Australia. So for unpublished works in Australia, we have perpetual copyright protection. I've kind of wondered whether or not this is kind of constitutional or acceptable, and I've raised in past years many kind of objections to it. But this year our librarians and archivists led a campaign against perpetual copyright protection in relation to unpublished works. They engaged in a cooking for copyright bake-off and had unpublished recipes from their grandmothers and grandfathers and from libraries and archives. And they published them online, and they also kind of baked them. So they engaged in a baking bad protest against copyright law and tweeted it far and wide. And I was forced to consume many of these yummy cakes that you see before you as part of my kind of scholarly devotion to copyright. But I guess that kind of highlights some of the problems that we've had in Australia with the copyright term extension. And clearly, as a kind of a net importer of copyright works, it's had a significant financial impact and also had a larger impact upon our cultural heritage in the public domain. Canada now faces a very similar problem. You know, Canada has been very strong, I think, resisting pressure from the United States to have a copyright term extension, and sometimes resisting local pressure, with Lucy Maud Montgomery's estate pushing for a copyright term extension. But according to reports from Atlanta and some of the leaks that have happened, there will be a copyright term of life plus 70 years for the Trans-Pacific Partnership. We don't really know yet whether there will be a demand for the revival of copyright in works that were previously in the public domain, but that will have a very profound impact upon Canadian cultural heritage and competition and innovation. Jamie Love kind of noted that in the draft text there are a wide range of different kind of options for copyright term, but really they go far beyond the Burns standard of life plus 50 years. And, you know, as the father of a 10-year-old daughter, I'm very conscious of, you know, who will benefit from the copyright term extension. So, you know, obviously Disney is very good at managing this huge collection of archival copyright assets, like think about the Disney princesses, for instance, or the Pixar films that both my kids like, or for some of you Star Wars fans, you know, Disney have kind of bought out not only Pixar, but they've also kind of bought out Star Wars. So they're kind of interesting kind of questions there. You have kind of these big multinationals doing long-term management of copyright works, asking for license fees in relation to those works, and there being lots of kind of conflicts over it. Sometimes some of those claims are not very well made. So you might have seen the recent controversy over the Happy Birthday case, in which it was found that there wasn't a copyright owner of the Happy Birthday song, and Warner Chappell couldn't demand licence fees in relation to Happy Birthday. In some jurisdictions, it's even worse. So Blaine Haggart, in his recent book, has a really nice study of the Mexican situation of life plus 100 years, and Mexico were pushing the TPP for a life plus 100 years as the standard for copyright term protection. Obviously, there's going to be a lot more problems in relation to the problem of orphaned works. So orphaned works are works in which you cannot locate the author of a copyright work. They're deceased or lost, or the chain of title has moved. There's been lots of problems about how do you respond to some of the public policy problems in relation to orphaned works. You know, Canada relies upon the Copyright Board to have some sort of exceptional power. In Australia, we've been debating over how best to deal with orphan works. The United States had endless proposals that never seem to be implemented. There are going to be more transaction cost problems in which, you know, works come to the end of their commercial life, they're still in copyright protection, and there are issues in getting access to them. The National Library of Australia says that there are literally millions and millions of orphan works in their libraries. You know, copyright law automatically kind of allows for the creation of new works. Copyright is vested in those works. Even if they're not necessarily commercial works, and just ephemera, there are real issues there in terms of dealing with orphan works. So that's going to be a huge issue for Canada, I think, in terms of the current debate over the TPP. A more subtle debate has kind of taken place in the TPP over copyright exceptions. So there's been lots of fine academic discourse about the language used in the Trans-Pacific Partnership on copyright exceptions and whether or not that language is narrower than what is found in previous agreements, particularly the Berne Convention. There's a lot of discussion about the three-step test and how it's applied in relation to the Trans-Pacific Partnership. I mean, it's certainly a very powerful and prominent issue in Australia. In Australia, we have a limited defence of fair dealing, which is limited to Pacific purposes, criticism review, research and study, judicial proceedings, reporting the news. And in 2006, we got a defence for parody and satire, which I was very proud about because that was my honours thesis, and I spent a long time fighting for that particular defence. But there's a real problem for a wide range of other commercial activities like cloud computing or 3D printing or remix culture about whether or not that fits within our categories. So Professor Jill McHugh led the Australian Law Reform Commission inquiry into copyright exceptions, and she recommended that Australia should have a broad inclusive defence of fair use, and failing that we should have some new copyright exceptions. But unfortunately in Australia we haven't had the judicial creativity or innovation that we've seen in Canada in relation to the defence of fair dealing. Our judges have interpreted the defence quite narrowly, and unfortunately our High Court of Australia hasn't had the opportunity to make a broad ruling like the CCH case. I remember once Justice Kirby pleading with a barrister to make arguments about fair dealing, and the barrister, for tactical reasons, didn't want to make those arguments. So that's a really big issue for us, that we've accepted some of the worst aspects of United States law, but we don't have any of the flexibilities. We don't have fair use, and we don't have something like the First Amendment. We only have a very limited implied freedom of political communication. Canada, by contrast, has the dynamic defence of fair dealing. I've met your Chief Justice Beverly McLaughlin when she visited Australia. I said, what a good decision CCH is as a kind of a defence of users' rights and a very kind of broad interpretation of the defence of fair dealing, which has then been kind of augmented by the copyright pentology. The other day I saw a really interesting speak by Justice Binney at the University of Toronto. He wasn't a judge for the pentology, but nonetheless he thought it was a good opportunity for him to give his opinion about those decisions. He says it all goes back to the Thieberge case, which he wrote, which took a very broad view of the role played by copyright law in defending the public interest, which was then elaborated on in the CCH case. He had a bit of an argument with Michael Geist. He said, Michael Geist says it's a seismic shift in Canadian copyright law in terms of the pentology of cases. He sees it as more of a natural continuity from some of the earlier precedents like CCH and the decision in Thieberge. So Canada has really kind of shown what you can do with the defence of fair dealing. Really interesting kind of discussion. By contrast, the United States has the broad, flexible and inclusive defence of fair use, which covers some very traditional purposes but has also been deployed to deal with lots of other activities. So scholars like Professor Pam Samuelson and Peter Jarzy and Pat Ofterhide have discussed the range and scope of the defence of fair use, how it's being used for license or a wide range of different circumstances, appropriation art, sometimes musical sampling, questions about literary sequels and shadow texts, as well as thumbnail images. Peter Jarzy has kind of noted that one of the reasons for the cultural competitiveness of the United States has been the broad and flexible defence of fair use. It's given a certain freedom for start-up companies and innovators to pursue their inventions without fear of litigation in relation to copyright infringement. Pam Samuelson also kind of makes the point that the defence of fair use has played a very significant role in terms of protecting freedom of speech and tackling some of the problems in relation to censorship. Pat Ofterhide and Peter Jarzy of late have been very interested about how different creative communities have used and deployed the defence of fair use. So they've talked about the development of codes in relation to fair use for different creative communities, journalists, documentary filmmakers and others. So there's been a great deal of debate about what should happen in the agreement. There seems to have been a bit of a push by some of the big IT companies to have some sort of statement recognising fair use in the agreement. The Motion Picture Association of America has been very grumpy about that and has been kind of complaining that the text is too broad for copyright exceptions in the agreement, whereas copyright users like the Electronic Rights defenders, like the Electronic Frontier Foundation, have basically been saying, well, Hollywood heavily relies upon fair use for lots of their films and lots of their works, but they also make the point that they're generally concerned about the scope of the text in relation to copyright exceptions. So Jamie Love in particular is concerned certain aspects of the Berne Convention are not necessarily picked up in the agreement. Very interesting discussion about how the Trans-Pacific Partnership will affect creative artists, be they filmmakers or academics or biographers or 3D printers, makers. A wide range of different creative artists have been quite concerned about how the TPP will affect copyright exceptions. Filmmakers like Brett Gaylor from Canada and Andrew Hunter have been saying copyright law should uphold a carefully crafted balance of public and private rights that encourages creation while providing incentives for innovation, access for education, libraries and other socially beneficial purposes. Another really kind of important issue in terms of copyright exceptions has been the question of copyright law and disability rights, which has been a kind of a fascinating subject of debate in the World Intellectual Property Organisation. So Australian Francis Gehry as Director General pushed for the Marrakesh Treaty on copyright law and disability rights, against some of the objections of some member states and some industry groups. There's been an agreement on that text, which will help the dissemination of books for those with visual impairments. Certainly a fascinating area, both as someone who does copyright law and as someone who's also a disability carer. I think it's a really kind of fascinating area of copyright law in terms of an effort to deal with disability discrimination and a real failure by copyright law to respect human rights. I think the partially good thing that happened during the kind of discussion in the Trans-Pacific Partnership was a kind of a recognition that there needs to be some sort of acknowledgement of the Marrakesh Treaty. So a number of Australians have played a very kind of key role in this debate. Ron McCallum, who used to be Dean of the Sydney Law School, Graham Innes, who used to be Disability Discrimination Commissioner, and the wonderful Marianne Diamond, all played a kind of key role in terms of getting the agreement up. There seems to have been a bit of an effort in the Trans-Pacific Partnership now to recognise the Marrakesh Treaty. I am still kind of concerned, though, about certain elements of the agreement not necessarily being very helpful or useful for those with disabilities. So the provisions on technological protection measures, for instance, seem to me overbroad and not very helpful. And I guess also important to remember that the Marrakesh Treaty doesn't necessarily deal with a wide range of disabilities in terms of what it actually deals with. So, you know, some disability rights activists argue that there's a need for much broader and stronger copyright exceptions to deal with some of the problems of discrimination that have kind of taken place. So that's a really kind of fascinating area of debate in relation to copyright exceptions. Next kind of key kind of couple of areas really deal with elements of the Digital Millennium Copyright Act. And I guess that's kind of particularly important for Canada. You know, the United States has been trying to export elements of the Digital Millennium Copyright Act now for many years. Some countries like Australia have surrendered and incorporated some aspects of the Digital Millennium Copyright Act into their regimes. But Canada, for what it's worth, has been willing to defend a certain Canadian-made law in relation to copyright law. So, for instance, in relation to intermediary liability, you have a notice and notice system rather than a take down a notice system. I think, you know, there's a long annex dealing with intermediary liability. The push in the Trans-Pacific Partnership is upon all countries to adopt a very US-style model for dealing with intermediaries. I've heard some commentators like Professor Ariel Katz raise questions about, you know, the relationship between the model being pushed and the Canadian Charter of Freedoms and Rights. His argument is that, the reason Canada adopted a notice system was there were charter concerns about a much broader takedown and notice system in relation to copyright works. But I guess my kind of concern is that the 1990s model that was developed in relation to intermediary liability was in many ways a premature regime that was developed before search engines played such a central role on the internet and before the rise of social media and mobile media of various different kinds and blogging and microblogging and tweeting. The model of the Digital Millennium Copyright Act is not necessarily well designed or well adapted for the new digital millennium. So it really disturbs me that the United States is putting forward that rather broken model and is trying to lock the other countries across the Pacific Rim into that very rigid and inflexible model. And I guess we're kind of in a very kind of strange moment in terms of the way in which takedown notices are being used. So as the Chilling Effects Clearinghouse has shown, really there are thousands upon thousands of takedown notices that are sent every day, often by bots. So not even humans are necessarily sending the takedown notices. And often they're kind of being responded to by intermediaries also in a very automated way. Copyright law has become very automatic for the people. But in terms of the practices that are kind of taking place, it really kind of concerns me that there's not a lot of respect for some of the interests of consumers and creators and citizens, particularly around questions about fair use. And I guess there's been some very titanic battles in the United States about what the regime actually means. So Viacom famously took on YouTube for copyright infringement. YouTube and Google were able to raise larger arguments about safe harbours. But YouTube and Google then went to a content ID system to try to better police infringing works. That mega litigation shows you some of the kind of grand issues at stake in relation to intermediary liability. But there are lots of kind of submissions by friends of the court raising larger concerns about how takedown notices could affect freedom of speech and cultural activities and a wide range of other forms of deliberative democracy. I think a really important and significant precedent recently was Stephanie Lenz's great victory over the dancing baby video. Corinne McSherry from Electronic Frontier Foundation was defending her. Famously, she had a YouTube video of her baby dancing to a Prince song, and it became a bit of an internet sensation. Universal sent down a takedown notice. Essentially, Stephanie Lenz kind of complained that that was improper. And finally, there seems to be a recognition in the Court of Appeals that there's a need to take into account fair use in terms of considerations about takedown notices. But it certainly highlights for me some of the problems in terms of the regime. It's taken 8 years to deal with such a simple question. The baby now is probably in high school. It's not necessarily a very efficient or well-ordered system. And similarly, there's been lots of kind of big battles of late testing the limits of the system, like the Garcia-Google battle over the Innocence of the Muslims video, which raised lots of large kind of interesting kind of issues. So I guess there are kind of really some profound new questions in terms of how those intermediary liability regimes are working. As Cory Doctorow notes, we have a new networked universe and many, many new intermediaries, and some of those issues are kind of very profound. Obviously, there are very kind of great deal of concerns about copyright owners placing the burden of enforcement onto internet service providers and telecommunication carriers and search engines to police the networks for copyright infringement. Equally problematic is the push in relation to digital locks, known as technological protection measures and electronic rights management information. Again, this comes out of the WIPO Internet Treaties and the White Paper in the 1990s. Digital Millennium Copyright Act in the 1998 kind of invented this new regime of Uber copyright. Australia in 2000 had the Digital Agenda Act, and we had a kind of an Australian-made system. Our High Court of Australia had a really good decision on technological protection measures and tried to read them in a very narrow way in Stevens versus Sony, and said that there were great deals, a wide range of problems with the abuse of technological protection measures for anti-competitive purposes and dividing up markets and charging higher prices. but Australia in 2004 had to adopt a US model in relation to technological protection measures. Obviously, this is very kind of controversial. In the United States, the regime has been interpreted in a very broad fashion, and often in a way that kind of overrides existing defences and balances which exist in relation to copyright law in the United States. And also, as some Canadian commentators like Professor Ian Kerr from the University of Ottawa have kind of pointed out, a lot of the digital rights management systems have also been used for reasons of surveillance. So you had the Sony BMG rootkit scandal, in which purchases of CDs had rootkits installed by Sony that would send messages back about what consumers were doing. In Australia, this is a larger public policy problem because we've had huge scandals over IT price gouging. So we hoard Adobe and Microsoft and Apple before the Parliament of Australia to get them to try to explain why Australian consumers were paying far more for products that were available online from the United States and Canada for much cheaper prices. And what they were really using, amongst other things, some old parallel importation restrictions, which were still present, but mainly they were using geo-blocking and technological protection measures to kind of charge premium prices for Australian consumers. So we've certainly been very kind of concerned about that, and New Zealand has also been very concerned about that. Bit of a debate still these days about can you reform technological protection measures. I guess the problem with the TPP is that it doesn't give you that opportunity. It locks in that kind of model in a very rigid way and doesn't give you kind of flexibility to change or modify that without the agreement of the 12 parties. Some commentators say it's time to really abolish technological protection measures altogether. So Cory Doctorow and the EFF say that we need an Apollo 1200 mission to eradicate digital rights management systems in our lifetime. Bit of an in-joke, the provision in the US Copyright Act is section 1201. So he basically says, we need to get rid of digital rights management, we need to get rid of digital locks and technological protection measures. They haven't worked. They were introduced in the 1990s, and then you had the great explosion of copyright infringement that happened with Napster and the peer-to-peer networks. And since then, we've had torrents and lots of other things happening. Digital locks have not necessarily stopped copyright infringement, and also they've had a lot of adverse impacts upon competition and privacy and access to knowledge. There's also some really strange little bits of corporate welfare in the nooks and crannies of the Trans-Pacific Partnership. So recently there's been a lot of debate over traditional television broadcasters being upset by competition from streaming services and internet TV services. Rupert Murdoch, formerly an Australian, for corporate purposes now an American, has been particularly upset at what he sees as the kleptomania of the new economy. And if you kind of look at some of the text, there's some very kind of strong language there about providing protection for television broadcasts and saying that no party may permit the retransmission of television signals, whether terrestrial, cable or satellite, on the internet without the authorisation of the right holder or the rights holders. So there's been a bit of discussion about whether there's a little furtive attempt here to do something the copyright owners have been trying to do with the WIPO copyright television broadcast regime. So it's very sneaky, but very kind of pertinent if you kind of think about the litigation, for instance, that took place in the United States over Aereo. In Australia, we had a big copyright battle over Optus TV Now, over allowing its subscribers to watch Australian Football League and rugby games instead of it being monopolised by Telstra, the official telco provider. So that's a really kind of live and important issue. So there's some discussion that there's anti-Aereo text. Just to wrap up, I think it's worthwhile kind of emphasising that there is a heavy effort to boost intellectual property enforcement in the Trans-Pacific Partnership across the various disciplines of intellectual property. So particularly in relation to copyright law, there's a push for wider, stronger civil remedies. There is a very pronounced criminalisation of copyright law. There are border measures that have been introduced, but there's no kind of countermeasures necessarily against abuse of copyright or copy fraud or anti-competitive uses of copyright law. Similar patterns in other areas of intellectual property. So trademark law, there's a heavy emphasis on civil and criminal remedies in relation to trademark counterfeiting. Very dramatically, the United States has been demanding stronger criminal penalties and procedures in relation to trade secrets. That hasn't really been widely recognised, but I think that would be a very radical development. And there's also some heavy duty remedies associated with patent law and some associated sui generis forms of intellectual property like data protection and biologics. And as I kind of said at the outset, I think it's kind of really striking that there's been a little bit of historical amnesia in the debate of the Trans-Pacific Partnership, because just several years ago we had a huge controversy over the Stop Online Piracy Act and copyright owners trying to pass laws that would give them incredible superpowers like blocking foreign websites. There was huge outrage over such a proposal. Aaron Swartz and others led the campaign against the introduction of that. Congressmen and women switched votes against the Stop Online Piracy Act after their phones went into meltdown. There was a nerd revolution and the internet rose up in revolt against SOPA. And in a very similar fashion, there was a kind of a great uprising against the Anti-Counterfeiting Trade Agreement, which had measures dealing with copyright piracy and trademark counterfeiting and border measures. And you had a very much a kind of a moral panic about intellectual property infringement. There was a kind of an effort to use the language of outsiders. We need to take stronger action against pirates and counterfeiters. But really there was a great deal of resistance in the European Parliament and in Australia and elsewhere because of deep concerns about how some of the measures would affect freedom of speech, innovation and competition. And in Australia, I guess it's been very kind of disturbing that we've kind of had a bit of a pincer movement. We've both had the Trans-Pacific Partnership pushing forward new copyright measures, but our Attorney General, George Brandis, has been very much influenced by the film industry in Australia. So Roadshow, who you might know as the makers of the Lego Movie and Mad Max, have made huge political donations to the major political parties after losing a big High Court case against IONET. And under the command of George Brandis, he passed just during the winter break a copyright censorship bill that would enable copyright owners to ask a court to filter the internet, to block access to foreign websites that are accused of infringing copyright or facilitating copyright infringement. The language of the agreement is very peculiar indeed, and key terms are not properly defined, like what is facilitation. So Australia's kind of been very radical in terms of we've just passed some very kind of significant new superpowers for copyright owners. And we've also kind of introduced a new code to demand that internet service providers go through more detailed steps in policing copyright infringement by their subscribers and their users. Again, heavily motivated by Roadshow and some of the other copyright owners. Interestingly, our new Prime Minister, Malcolm Turnbull, had to introduce some of that legislation, but he wasn't necessarily very happy about it. So he took the portfolio of copyright law away from George Brandis as one of his acts as Prime Minister a few months ago. So there's some tensions within the ruling party about how best to deal with copyright law. We've had some fascinating litigation. So the Dallas Buyers Club have been engaging in speculative invoicing around the Pacific Rim. So in the United States and Canada, they've been sending off demanding letters saying pay up for torrenting or downloading the Dallas Buyers Club. In Australia, our court has been quite good at trying to manage the situation. So Justice Perham said, the only way I'm going to allow you to send out letters to Australian consumers is if you post a $500,000 bond, because you're not based in Australia, so we need some sort of security. And I'm going to kind of control the information that you can send to consumers. So a really interesting judgment that's just been made, tries to deal with the interrelationship between copyright law, consumer rights and privacy, but really deals with some of the problems of copyright trolls who try to use copyright law in quite an abusive fashion. I mean, there's a bit of debate about who owns the Dallas Buyers Club. Someone does seem to have claim to the copyright, but there is a kind of a question about how you go about bringing actions against individual users of systems. I guess the other really noticeable thing that's been happening is the criminalisation of copyright law. Very broad framing of the offences that might be captured in terms of copyright infringement that might attract some sort of criminal offence. So there are provisions there dealing with quite commercial matters, but the definitions seem to be broadening to also include other circumstances where commercial motivations might not necessarily be the key ones, where there might be kind of willful dissemination of copyright works. And there's also quite a lot of language there in relation to importation as well. I guess it's well worth thinking about the sorts of cases involving criminal copyright that are starting to appear in the Pacific Rim at the moment. So in New Zealand, there's been a fiasco of a copyright controversy over Kim.com. So the New Zealand government helped copyright owners conduct a raid on the property of Kim.com. Kim.com ran a Mega Upload, a cloud computing service. There's kind of ongoing litigation in New Zealand with the Department of Justice trying to extradite Kim.com to the United States to face various criminal copyright charges. And that's kind of coupled with civil action in the United States against Kim.com. Lawrence Lessig wrote a really kind of interesting submission to the New Zealand court, talking about some of the larger issues about the criminalisation of copyright law. His concern was the fate of Aaron Swartz. You know, famously Aaron Swartz kind of committed suicide after being prosecuted under the Computer Fraud and Abuse Act. As a result of that experience, Lawrence Lessig has been very kind of concerned about some of the actions of the Department of Justice, both in relation to matters of intellectual property and also in relation to matters of information technology. Copyright owners have been promoting the Kim.com case both in ACTA and the TPP as a kind of an instance of the need for greater harmonisation and greater cooperation. Professor Susan Sell from the American University has kind of highlighted that some of the texts on soft harmonisation, cooperation is really important in terms of kind of engaging in cooperative action across multiple jurisdictions. So that's a really significant controversy to look at. And the Department of Justice is starting to use extradition powers quite a lot. So in Australia, we had a Wares operator called Raymond Hughes Griffiths, who was extradited from Australia to the United States, was put in prison, but he had never actually visited the United States ever in his life. So fascinating developments in criminalisation of copyright law. Heavy emphasis too in terms of border measures. So customs authorities having greater seizure and destruction powers. Practically, they're always very important. I was a brand enforcement officer during the Sydney 2000 Olympics, and the IP managers there often used customs to try to hold things that they were thought were infringing copyright or trademark until after the end of the game, so they would have no kind of commercial market. So border measures are practically kind of quite important as well. It's noticeable that their efforts to have remedies against some of the problems like copy fraud or abuse of copyright haven't really entered into the text of the Trans-Pacific Partnership. I think that's very disappointing. Jason Mazzoni has kind of talked about the problem of copy fraud, where you have individuals claiming copyright protection in relation to works that have fallen into the public domain. So, huge problem. So Katy Perry, for instance, made a very dubious copyright claim over Left Shark. And Chris Brigman was busy defending a 3D printing maker who had distributed a version of Left Shark on Shapeways. But the argument there was, you know, what copyright claim did Katy Perry have to Left Shark? Had she designed Left Shark? You know, was a costume really the subject matter that could be protected under copyright law? So I think increasingly that's kind of quite a big issue and quite a big problem. We do need equivalent remedies to deal with abuse of copyright law. So just to wrap up, I think the Trans-Pacific Partnership is radical in the implications that it has for the objectives and purposes of copyright law, but also to some fundamental doctrines that exist in relation to copyright term extension, copyright exceptions, questions about intermediary liability, issues about technological protection measures, and some of the remedies that are available. In addition, there are other chapters within the Trans-Pacific Partnership that will further augment the rights of intellectual property owners. So the investment chapter will be critically important because it defines investment as including intellectual property. So at the outset, I kind of talked about the controversies over plain packaging and in Australia and drug patents in Canada. It's conceivable that a copyright owner would have similar powers under investor-state dispute settlement to bring an action to a foreign investor tribunal complaining about government regulation that somehow adversely affected their foreign investments. So a copyright owner, for instance, Hollywood or the music industry, could object to new copyright law reforms, say a defence of fair use or action on IT policy. They could object to issues like media law reform in terms of rules about media ownership, or something like network neutrality or local cultural content rules. Except for Canada. Canada was smart and has a special exclusion in relation to investor-state dispute settlement governing local content rules, but Australia would certainly be kind of open. So the combination of intellectual property and investor rights is a very radical development. There are a few limitations in the draft text revealed by WikiLeaks about what actions you can bring in an investor regime in respect of matters of intellectual property. But it seems to me extraordinary that copyright owners, in addition to the suite of remedies that they already have available, will have these superpowers to challenge government decisions and demand compensation for decisions that might adversely affect their foreign investments. And also, as I kind of alluded to before, I think the electronic commerce chapter is really significant. And I think one of the reasons why Big IT has been so keen on the Trans-Pacific Partnership is that they think that the electronic commerce chapter will help deregulate rules governing electronic commerce across the Pacific Rim. So the idea will be that it will prevent domestic countries from regulating electronic commerce so much. So the Electronic Frontier Foundation are concerned about how that will affect data sovereignty and privacy and network neutrality and the use of open source software. So there's a really kind of interesting question about how these different chapters of the Trans-Pacific Partnership will interact with one another. But it looks like at the moment the Trans-Pacific Partnership is hurtling along at a fast pace, and a lot will depend upon the individual debates that take place in members of the negotiation, and it will be interesting to see whether Obama will be able to get the deal through the US Congress with his fast-track authority, whether Bernie Sanders and Hillary Clinton will exploit the Trans-Pacific Partnership during the presidential race, and what's going to happen in Canada with the election in terms of what responses will be to the Trans-Pacific Partnership as part of the election and with the new parliament that you're going to have. But it will certainly be a very kind of prominent issue in Australia as well. So thank you very much.
I think that was absolutely first rate. You've covered so much ground in just about over an hour, something that I think would take a whole course in one of our terms to cover. Yeah. And I think right now we're a lot more illuminated on what the TPP is than we were before coming into this room. I loved your references to Mickey Mouse, so it's a Mickey Mouse kind of deal, and also harkening back to Michel Foucault, discipline and punish approach. Yeah. So it's very much a discipline and punish type of deal. You've given us a lot to think about and I think worry about. So with that, we have time for some comments and questions, and I see some hands going up, so why don't we...
Happy to take questions about copyright law, but if people have also broader questions about the Trans-Pacific Partnership, I'm happy to kind of discuss some of those, because I alluded to a few of those, and some people might be more excited about trademarks and patents and trade secrets, and might
Okay.
like some of those issues.
Okay, wonderful. I see one question back there. So now I'm just going to come with the recorder so make sure we have everything.
Well, you don't have to be sure to have everything, at least not right now. Hi, and thanks so much. That was just spectacular. While you were talking, I was having memories of a street I walked down in Kuala Lumpur. It's the busiest street of Chinatown. And just potentially getting pummeled by bags that said names on them that I thought, how do I translate this moment in Canadian terms? And then finding out about the folks who were selling them, who were, I'd consider in a very difficult personal situation, like it was a lot of immigrants from Myanmar and other difficult circumstances. And I think for me, I was wondering about the TPP and the sort of international relations discussions it'll have amongst countries that ends up being about domestic labor issues. And I was just wondering if you had any reflections about that, because when I was seeing all these bags I could have bought for $5 and was just like, oh, that's not cool. At the same time, I learned that some of these stalls were being run by the people who that job was a stepping stone to improving their children's circumstances. So I found myself really, really torn how I thought about copyright law at that moment, and actually going from one extreme of thinking this is horrible to another extreme of it doesn't hurt me too much that there's copyright violations going on. But anyway, I just thought I was really inspired to sort of think about labor issues internally in countries and how that topic might be part of conversations amongst countries as well. Thank you. She's waiting for the mic to go there or something.
Really good question. It's certainly a question that resonates with me. Both my parents are geographers, so my father, who's still going strong as an emeritus professor at the age of 80, specialises in human geography in Southeast Asia. And I can't remember going off with him at quite a young age to Malaysia and having a very similar experience to the one that you had. Showing my age a little bit at this point, I can't remember. The Blues Brothers was just a big hit at that particular time, so it must have been about 1982 or so. And you had lots of these, obviously infringing copyright works of tapes of the Blues Brothers that had been kind of made. I think interesting issues in terms of Malaysia for intellectual property, both in terms of copyright, and I do think that there has been some serious issues in relation to copyright infringement in Malaysia, as well as also being some significant issues in terms of access to knowledge. Very significant issues in relation to access to essential medicines. So I've had a bit to do with some of the HIV/AIDS networks based in Malaysia. I'm concerned about how the TPP will affect them. And also, as you kind of mentioned, quite a few trademark issues. As you kind of very perceptively kind of pointed out, there are kind of larger issues here about international relations and labour rights and human rights. And I think Malaysia in particular has come under a lot of scrutiny in the Trans-Pacific Partnership over its appalling record in relation to human trafficking. So a number of members of Congress wanted to exclude Malaysia from the Trans-Pacific Partnership talks because of some of the issues with human trafficking, particularly from Myanmar over to Malaysia. And that was a very kind of powerful kind of debate that's taken place. A lot of controversy over the State Department setting their rating for Malaysia at such a level to allow them to participate in the Trans-Pacific Partnership. So I think that's a really interesting debate about labour rights and human rights. There's a lot of debate about the labour rights chapter. President Barack Obama has been busy saying that the agreement contains the strongest labour standards of any trade agreement, but really unions around the Pacific Rim have been very concerned about how the agreement will affect jobs and labour standards and certain industrial rights. There's certainly been a bit of concern about Malaysia and Vietnam and Brunei about whether or not the agreement will provide international labour organisation standards of protection in relation to kind of labour rights. But they're kind of interesting issues there. The history of intellectual property has always kind of also been one of legitimate markets and black markets as well, and that's always been quite an interesting kind of issue. But you can certainly see, the Trans-Pacific Partnership as a kind of an effort to crack down on certain kind of black markets and stopping the physical trade from certain jurisdictions to other countries like the United States and Australia. Yeah, so the border protection.
10 Baker bags to stay in Malaysia.
Yeah, so that's certainly, I think, a significant, but also I think, some of the intermediary liability kind of issues as well as a kind of a way, if you think of things you can buy on eBay, for instance, those sorts of kind of electronic commerce matters are kind of quite interesting as well. But yeah, quite differential impacts in terms of the countries that are involved in terms of the agreement, and really interesting complex issues about international relationships between the parties that are involved.
Okay, there's a question here.
First of all, I echo everybody's thanks for your presentation. The event you were at last week down at U of T, sadly, they booked a room that was too small, and a great many people, me being one of them, couldn't get in, and so I watched it on a computer screen. So you would have been a great addition to the presentation. I'm delighted I had a chance to see you in person. You talked about President Obama and fast tracking, and that's certainly an extraordinarily powerful measure that basically takes any real chance for intensive scrutiny of the contents of a treaty off the table. It may not have become well known outside of Canada, but we have our own kind of fast track that's been achieved entirely extra constitutionally by dear leader, because what he has done repeatedly is to submit gigantic omnibus legislation in which really nobody knows what's in there, because there is no time given to Parliament to consider it in committee for more than a cursory few sessions. There is no debate on it in the House, and amazing number of things have been punched through in these bills. I honestly believe, I don't think I'm being hyperbolic when I say that if the Conservatives are re-elected, the TPP, once it is in final form, will simply be buried in a piece of omnibus legislation, announced as a great triumph and voted on in the course of one day, and there will be no public scrutiny whatsoever. And that, given the scope of what you've spoken about today, is a very scary prospect.
Absolutely. Thank you very much for those excellent questions. Earlier versions of my talk really looked at the fast track debate that was going on in the United States. And I think it was a really fascinating dispute that broke out in the United States Congress. The Democrats, by and large, resisted the push for the fast track of the Trans-Pacific Partnership. So Senator Elizabeth Warren, former bankruptcy professor, was a very articulate opponent of both the process surrounding the Trans-Pacific Partnership and the secrecy surrounding it, but also how the deal itself would affect financial regulation and public health and labour rights. A number of other key leaders in the Democratic side of politics were very concerned about the agreement. So Levin Sanders, who's kind of an elder statesman of the Democrats, engaged in very significant critiques of the proposals, as did some of the progressives. But Nancy Pelosi, really at the end of some of the debates over fast track, kind of complained that really the United States needed a new model of trade altogether, and she was highly critical of Obama pushing through the deal. How did Obama get it through? Well, it was a bit like the House of Cards. Really, Obama essentially was very cunning. So he switched a key Democrat. So Ron Wyden, from Oregon, had been the big critic of SOPA and ACTA, and he was given a position in the Finance Committee as kind of a key leader. And he switched from being a critic of the TPP and its lack of its transparency to an apologist for the TPP. And he kind of organised some of the votes that Obama needed to get the deal through. US politics is very strange. They're very kind of concerned in the Senate about the filibuster. So they needed 60 votes or more to stop the filibuster. So he got that first up, went to the House of Representatives. There was a bit of a rebellion in the House of Representatives. For the fast track bill, they barely had enough support. But for the trade assistance package, there was a great resistance to that. The Republicans, by and large, were very supportive of Obama in relation to the fast-track bill. The political strategy was if they have a president next, they can then use that fast-track power. The Republicans, though, used a lot of omnibus legislation to try to control and limit what Obama could do in relation to the Trans-Pacific Partnership. So, for instance, there's text in the customs bill against Obama taking action on climate change, about doing anything on immigration policy, and various other things. So your point is a very good one. Obama then, had the bill back in the Senate. The Senate passed the fast-track bill, and then the opposition faded and they passed the assistance package. For Canada, I think there's been some very interesting things going on. I saw Professor David Boyd, who was talking about environmental laws, and he was expressing very similar concerns to yours about the omnibus approach to kind of gutting various different laws and various different areas of science. But I think there are huge problems in terms of the processes in Canada in terms of negotiating some of these agreements, not only the Trans-Pacific Partnership but also CETA, the deal with the European Union, which has been very controversial. Australia, in some ways, is even worse off. We have a very broken treaty-making process. So Professor Hilary Charlesworth, who's our best international lawyer, was on the ICJ, and Professor George Williams, our most famous kind of public lawyer, wrote a great book called No Country is an Island, in which they kind of complained that Parliament had a very weak role in oversight of treaties. In our system, the executive has the power to enter into agreements. Parliament has the Joint Standing Committee on Treaties, but at most it can block implementing legislation. So for Australia, really the political debate is, can the Australian Labor Party and the Greens and some of the crossbenchers in the Senate block certain aspects of implementing legislation? So that's kind of very problematic. Parliament is very kind of weak. But I think your larger point that you're getting at is that, in these processes there is an expansion of executive power, but also there are very distinct threats to the role of parliaments throughout the Pacific Rim, both in terms of the treaty-making process, but also through the inclusion of measures like investor-state dispute settlement, which might have a chilling effect upon lawmaking in all sorts of areas. If you want to do something progressive or innovative, an industry group from overseas can always threaten that it will take you to a foreign investor tribunal and you'll have to pay billions of dollars of compensation if you lose. So there are some very kind of profound issues there for political science students and scholars in terms of the transformation of the politics taking place under the Trans-Pacific Partnership.
Again, thank you very much for your talk. I did have a question regarding what your perspective was on why so much political capital would have been invested into pushing the TPP, particularly in Canada, where most economic projections don't seem to really be showing us benefiting all that much from it. So I'm just sort of curious to know what your opinions are on that, granted that the IP implications are so strong.
That's a really good question. So the question really kind of relates to the question about how do you engage in an analysis of some of the impacts of these mega trade deals like the Trans-Pacific Partnership. And that's certainly been a very pertinent issue in Australia and Canada and the United States. In Australia, the Productivity Commission has been very critical of the Department of Foreign Affairs and Trade about the analysis that it undertakes when it enters into treaties and agreements. So it has complained that the Department of Foreign Affairs and Trade oversells the benefits and underreports some of the costs, particularly some of the long-term costs associated with trade deals. And they think that there's a structural problem in the way in which Australia negotiates trade deals. The Department of Foreign Affairs and Trade is in charge of the negotiations, but it's not necessarily subjected to any kind of independent evaluation by Finance or Treasury or the Productivity Commission. And that was certainly highlighted for us in one of the debates over some of the bilateral trade deals that we've done. So we've, in addition to the Trans-Pacific Partnership, we've also cut deals with Korea, China and Japan the Korea-Australia Free Trade Agreement, the Japan-Australia Economic Partnership Agreement, and the China-Australia Free Trade Agreement. For the China-Australia Free Trade Agreement, the government made some very outlandish claims in relation to the jobs that would be created. And then our great economist working for The Age and the Sydney Morning Herald, Peter Martin, just pointed out that they had made a basic maths error. And really, overall, the jobs were kind of quite small that were kind of created. So there's a lot of debate about the economic impact of the trade agreements, whether it be good or ill. Sometimes very grand claims are being made by a number of the countries in relation to the deal. So Obama and Harper and Turnbull and Key in New Zealand have all kind of argued that it will boost jobs and innovation and growth. But others have been much more sceptical and have pointed out that past trade agreements have been overhyped and have not necessarily delivered on those promises. In Australia and in Canada and the United States, that's been a very kind of significant issue. And often jobs have been lost. So in Australia, a lot of controversy about the Korea and Japan deals leading really to the collapse of our local car industry. And that kind of really evaporating as a result of those deals. Some of the issues are kind of very complex too in terms of the evaluations that have to be made. For the Australia-United States Free Trade Agreement, we had Philippa D from the Productivity Commission, and she tried to do an economic analysis just of the copyright term extension. And that was a very kind of complex piece of work that she needed to do for that, using some of the statistics from the Australian Bureau of Statistics. I think it's a very complex exercise trying to evaluate what's going on in the intellectual property chapter. We had a good study on drug patents and the costs of drug patent extensions and the cost of biologics by Professor Di Nicol from the University of Tasmania and Nick Gruen, who's an economist. So that informed some of our debate. Some of the issues are really kind of hard to contemplate. So investor-state dispute settlement, for instance, there's been a steady rise in the number of actions. Initially for NAFTA, the expectation was that there would be very few actions, particularly against Canada or the United States. And Canada has faced a huge number of actions in terms of investor actions. So the contingent liabilities in relation to the certain issues are kind of hard to project, particularly because investor actions have been driven by creative, innovative global law firms who see it as a growth market and have been interpreting investor clauses in very significant ways. So some of those impacts are going to be very kind of long-term impacts. And that's why I think the TPP is a very hard deal to evaluate as well, because it's a preferential trade deal. It has market access in certain sectors, certain other areas are still protected. There are certain new monopolies that are created. So Nobel laureate Joseph Stiglitz has been saying the TPP is not about free trade, it's about entrenching corporate power and certain monopolies. And he was quite concerned about it exacerbating inequalities within countries, but also kind of between countries as well. And he was also kind of concerned about the countries who are excluded altogether. So Professor Jeffrey Sachs, his colleague at Columbia, thought the TPP undermined the development goals in terms of the Millennium Development Goals and Sustainable Development Goals. But there's a really kind of quite interesting debate going on amongst economic specialists about how you evaluate something like the Trans-Pacific Partnership. But I think Michael West in the Sydney Morning Herald had a nice kind of line yesterday, and he basically said, you should kind of take some of the claims being made about the Trans-Pacific Partnership with a grain of salt. It's a bit like being told you should buy this used car and not inspect it at all. He thought it was a very kind of blind process at the moment in terms of not being able to kind of see the text or analyse the text or evaluate the text. And you can't necessarily trust some of the promises that are being made about the agreement.
We have a few more questions.
Thanks for a very interesting talk. I was thinking about Gus Van Harten's recent analysis of the Chinese-Canadian investment treaty. And apart from the obvious wish of the Harper government to do deals on oil production in the West, it seems to me his his analysis suggests, first of all, that complex deals electorally are very useful for particular kinds of governments, which you've referred to, but also they're very difficult to understand. And I mean, he portrays Canadian journalists as totally derelict in their analysis of that treaty. And he also points to the fact that there's a vested interest in the international lawyers who handle this kind of thing and do it in complete secrecy. And I was wondering if any of those things particularly resonate with the TPP.
Yes, now I've come across Gus Van Harten's work. He's based here at York University, and he's kind of written some interesting things about the deal done between Canada and China, and also the Trans-Pacific Partnership. I mean, I think his points are quite resonant, given that we've also in Australia just entered into a trade agreement with China, and are kind of also kind of dealing similar deals in respect of the Trans-Pacific Partnership. There are some distinct kind of issues in terms of the public process. I mean, I think there is a very kind of closed community of insiders, both of trade negotiators and investment experts, who had preferred to take charge of the process in terms of the design of trade agreements. And certainly it was very interesting in the Australian Parliament that there were complaints not only from civil society and from academics, but also from small business and big business, that they had no clue about what was actually going on in relation to some of the deals and the agreements. I mean, I think the media has had quite a mixed performance in terms of its reporting upon the Trans-Pacific Partnership and some of the other big trade deals. So looking at the coverage on the Trans-Pacific Partnership in the past week, there were some problems in which some papers just repeated the talking points of the White House. So the New York Times had this shocking piece in which they said the Trans-Pacific Partnership is wonderful for the environment, and they kind of howls of protests from the Sierra Club and Greenpeace and Friends of the Earth and 350.org and Naomi Klein, who wrote This Changes Everything, kind of complained that it was a pathetic betrayal of the environment, and she thought it was very similar to what the White House had done in NAFTA. So there's been some, distinct kind of propaganda games being played with the media. Some journalists have a lot of experience in terms of dealing with these matters. So Peter Martin in Australia was around for the Australia-United States Free Trade Agreement a decade ago and has covered everything else and has a really kind of good knowledge. But it's very kind of dependent and contingent. And sometimes a lot depends upon the way in which civil society groups raise issues. So in Canada, someone who does work on agriculture, what was really striking was the farmers taking their tractors and their cows and encircling the Parliament of Canada and protesting against the Trans-Pacific Partnership. And you had some very funny exchanges in which, the police were trying to explain to the cows that they were to stay behind the protest barriers and not eat grass on the parliamentary hill. But, that had obviously a very powerful impact. One of the last things being negotiated at 5 a.m. before the final deal was dairy. Stephen Harper has made the extraordinary offer of $4 billion of compensation to farmers in Canada and another $1 billion to auto workers. It's a very strange argument that they're not going to be affected badly by the deal, but nonetheless, here's some compensation just in case. So sometimes a lot depends on how different issues kind of play out. Sometimes it's quite surprising to me. I mean, I was kind of surprised to the extent that biologics became such a huge issue in the final debate. It's a very special form of sui generis IP protection. The United States provides 12 years of protection. Australia has an approach after the Australia-United States Free Trade Agreement providing 5 years of protection. There was immense pressure upon Australia to accept 12 years or the compromise period of 8 years. Biologics are incredibly expensive. So some of the ones that we do have in our system cost $100,000 a year per person. So they're not necessarily very plentiful yet in terms of our pharmaceutical benefit scheme, but they are incredibly expensive when they're on that scheme. So sometimes they're kind of unexpected things that kind of surge up to the headlines, but then there are other things that are hidden. So it was noticeable that the Canadian government seemed to forget to report that there was a copyright term extension in its briefing on the Trans-Pacific Partnership. Obviously, it didn't want articulate, eloquent Canadian copyright lawyers, leading the charge for demanding further scrutiny of the Trans-Pacific Partnership on that particular issue. So certain kind of side deals are kind of quite hidden as well. And who knows what kind of actual trade-offs kind of happened in terms of the big package of measures that took place. But obviously a lot of opportunities too for industry capture of certain sorts of issues of one kind or another.
All right, well, that's time, and it's time to say thanks to all of you for joining us.